thank you for joining us. I want to thank you for joining us this morning. It's something that I'm very passionate about, and I think you are going to find this interesting. But please let me have your feedback afterwards. It's always interesting to hear what your ideas are, and we welcome any feedback. Okay, so it's really important to know that today's discussion is what has worked for me in the past. So it's really techniques. My background is originally a bit of litigation, but I've been working as a conveyancer since 2014. So yeah, I'm very excited to share with you 7 problem-solving techniques that really help clear out any misunderstanding, de-escalate any tension, and help us overcome those disputes that can really taint a conveyancing process with a bit of negativity. So we really want to stay away from situations like that. So in a market where our services are so compatible and comparable, and it's so competitive, what really sets us apart from others is not only our efficiency and how we do our jobs, but it's actually the strength of our relationships with our clients. So today we are focusing on a core truth that underpins long-term success, and that is that clients just don't come back to you because of what you do. They actually come back because of the way that you make them feel. So it's really important to build those strong relationship with clients. It's not just about check-ins or just selling the house or getting the rental secured. It's about consistent communication, trust, reliability, and creating a sense of partnership, that your client feels heard, valued, and supported. And with loyalty comes repeat business, referrals, and that is long-term sustainability. So that is essentially what we are looking at during this presentation. And so we will be exploring a few practical ways how to strengthen those relationships, even when there's disputes or misunderstandings or delays, because what we ultimately want is we want that human connection. It builds the relationship, and it also secures sustainability over the long run. So the traditional view and way of looking at disputes would typically be to pick sides. So I think we've all been there where we realize that ultimately I was instructed by the seller as an agent or as a conveyancer. And so one would think that you automatically have to side with your seller. That is the traditional approach, and sure, there is a place for that. It certainly makes sense in terms of legal responsibilities and the legal forum. But is that the correct way and the best way to always deal with disputes? So that's a controversial and an interesting take on things, and I'm certain some of the litigants listening will certainly disagree with me. But we need to also look at disputes as an opportunity. It's an opportunity to get to know your client a bit better, build a relationship with your client, and help secure their future support, their future referrals. We want to avoid quick solutions. We want to avoid fobbing off a client and saying simply, I can't help you. We rather want to work with them so that they don't end up feeling resentful or feel worn out or exploited. We want to build a relationship with them and help them. So the focus is really a sincere approach to help your clients. It's about finding effective solutions and making sure that the solution that we do find is one of mutual gain. So there's a classic example of the orange. So you've probably heard this example, and it's quite silly, but I think it really brings across the point. So A and B are both interested in the orange. There's only one orange. A wants the content of the orange to eat it. B wants the skin of the orange to bake a cake. If the solution was simply to divide the orange between A and B, essentially A would throw away the peel, half of the peel, and B would simply throw away half of the content. where if we got them together and they actually had a discussion about how they could both gain from the discussion, we could come to a conclusion where A gets the content and B the appeal, and it's a win-win situation. So yeah, in mediation, it's also true. I think we've all read it in court decisions. We've heard commentary about mediation that the best outcome is always the outcome agreed upon and not an outcome by an arbitrary or any third party or judge that doesn't know the background of the matter. It would be best to get our clients to work together to find a solution. So I'm going to start with the 7 techniques. And the first one, I really think is the most important one. And I think it rings true in every situation. And I think if we would, as professionals, put ourselves in our clients' shoes, we would want to be valued. So valuing your client and acknowledging your client's emotions is certainly the most important negotiation technique. So you cannot, after all, expect your client to work with you towards getting a solution if you haven't assured them that you're taking them serious, you're taking the problem serious, and you're working with them. You are their partners in finding a solution. So yes, valuing people is really important. John Maxwell has a saying which I really like. It says, connection is more important than correction. So if you connect with your client and you build a relationship at the onset, that connection creates trust and loyalty, and it's so important. And once there, that is what you need when a dispute arises, or if a dispute arises. Your client knows you, the way you operate, and you know your client. You know your client's background, your client's circumstances. And it's then so much easier to find a solution and to work with your client to reach a goal which is mutually beneficial and doesn't leave him alienated or feeling resentful. We can't always control everything, and sometimes things go wrong that we haven't foreseen or couldn't foreseen. And that is when we fall back on that relationship. And you can't start creating that relationship when things have already gone south. That's too late. It's very important to have that relationship from the beginning. It's also important to pay attention to the person and to hear them out. The clients are human, as are we. They have feelings, emotions, fears, and hope. And I think one of the biggest fears that we come across when we deal with property transaction is an expectation that cannot be met. So perhaps the client's fear is that he's going to be done in, or that he's going to fit a bill for something that is not his fault. So we need to address and acknowledge those emotions. We can't just say, well, sorry, I'm the seller's attorney or the seller's agent, or sorry, the contract says what it says, deal with it. We simply cannot afford to have that approach. It's really important, in my opinion, to hear your client out. Some of their feelings might be very well justified. So hearing them out, acknowledging how they feel, really just says to the client, look, I'm your agent, or I'm the attorney working on this file. I'm hearing you. I know there's a problem. I know the roof is leaking. We are going to find a solution. Allow me to come back to you. That just says you take everything serious and you're not leaving them out in the cold, but you are assisting them. So we really want a relationship of joint collaboration. We don't ever want a situation where our seller and our buyers, or our landlord and tenant, are attacking each other, or attacking the agent or the attorney. That's not conducive. And we don't want our clients to think back to the conveyancing process with negative connections. We want them to look back and say, wow, I received amazing service from this agent. This agent was there for me from the beginning to the end. I don't like the outcome, but the agent was amazing. That is what we want. It's important to always maintain a respectful tone. I know, and I speak of experience, when I say sometimes, a client just knows what to say to also trigger a bit of emotion on our side as the mediators or the conveyancers. But it's always important to keep calm and respectful, and to just take control of the conversation in a very calm manner. You want your client to be calm And you don't, we don't want for them to be angry or upset. And of course, certain feelings are justified, like feeling disappointed or feeling cheated. So the best we could do is really just to listen to them and to convey to them that we fully understand their disappointment. If I could give you a practical example. So if your buyer comes to you very angry that the day after transfer, the DB board is tripping, your client is attacking you, attacking the agent, attacking the seller, saying, oh, how could you transfer the property without a valid COC? This COC is not worth the paper it's written on. I'm sitting without electricity, and your client is very emotional. The best response would simply be to acknowledge the fact that they are disappointed, they are stressed, they are frustrated, and very well justified, and to convey to them that you'd acknowledge the challenge and you are going to take this up with the electrician and the seller. So be soft on the person, but be hard on the problem, because the problem remains substantive and there is an objective criteria to resolve the problem. But it's often how we challenge this problem or dispute that will determine the outcome. So strong relationships, like I said, really just builds a lot of trust and ensures that communication is smoother, and it builds a relationship that will help you resolve issues. Okay, so the focus is active listening, empathy, and just helping your client work through the problem and to find a solution. I think what's also very important in terms of valuing your client is participation. So going back to our example of the problems experienced with the DB board and the electricity compliance, we work with these types of scenarios every day. We know the answer is to contact the seller, to contact the electrician, and to get the electrician to go out. But be mindful that this could be the first time that your seller or buyer is confronted with a situation like this. The answer, which is clear to me and you, isn't necessarily clear to the client. So the solution could very much be to express to your client, I realize your frustration. Would it be okay with you? Would you be comfortable if I phone the electrician and get him to go back to the property? When would suit you? So just include your client in the conversation and allow them to participate, because you'll very soon realize what their interests are, what are their concerns, and how you can address those over and above what the actual challenge is. And that brings me to the second technique. And the second technique is all about serving your client's interest, not your client's position. So positions are stated demands. So that's when your client takes a very firm stance and say, I won't do this, or I'll never do that. I want 1 million bottom line, not a cent less. Or he just simply says, I refuse to conceive. So your client takes in a very firm approach. His position isn't necessarily his interests. Interests are the underlying motivations. Those are the reasons for the decision. And if you are sitting with a difficult situation or a dispute, it's important to distinguish the client's position from his interests, because we automatically assume that buyer and seller, landlord or tenant, have conflicting positions. But do they have conflicting interests? Because although their positions might be different, their interests might be aligned. So I want to share with you an example of a transaction that we did years ago. It was a buyer that was going through a divorce. So the divorce hasn't been settled yet, and we were busy with the transaction, and the purchase price was going to be paid from his divorce attorneys. So we were in the middle of the divorce and we were in the middle of the transfer. Our seller was quite nervous because we didn't have money on trust, and the money's coming from the divorce, but our buyer needs to move in. It's part of his divorce settlement that he had to move in. And so we had a big challenge. The position taken by the seller was occupation on registration. The position taken by the buyer was, I need urgent occupation, but I can't give you the money yet and we can't register yet. So we all know what the legal position is and what would be the best legal response. But in dealing with a dispute, it's important to note that both these clients have aligned interests. Both of them want the transfer to go through as quick as possible. Both of them would prefer occupation on registration, and both of them would want security in knowing this is happening. I am going to move, I am going to sell my house. So they've got aligned interests, and finding a solution can really be possible. You just need to think a bit creative and come up with a few suggestions. In that scenario, what we managed to do is the seller opened up his garage. The buyer could store all his furniture in the garage, and the buyer was able to secure temporary accommodation, and we moved the transfer date slightly earlier. The buyer also utilized alternative funds. So it's always good to look at the interest rather than the positions, because that's going to help you come up with solutions that would serve both clients' needs and concerns, because that's ultimately what we want to achieve. So we want them to engage. We don't want them to drag their feet. We don't ever want a situation where the client tells us, if I can't move in, I'm going to cancel the deal, or to take such a strong position. We'd rather focus each other on their dovetailing interests, because that will focus their attention towards finding solutions instead of attacking each other. Because remember, the moment they've taken a stance, they identify with that stance. They feel they need to defend it and attack any comments or any proposals that would contradict their position. It could very much become a matter of ego. It could become a matter of identity. And so one needs to be very sensitive and altogether just avoid that scenario by just highlighting to both parties some interests that are overlapping and that could potentially give us a solution. Okay, communication. So communication, of course, is crucial. It is pivotal in any transaction. And yeah, it's again, how we do it, not what we're doing. So as the estate agent or the conveyancer on the transaction, it's really important to communicate clearly and effectively. Poor communication could actually just amplify the whole situation or the negativity of the situation. It could lead to misunderstanding, misinterpretations, and escalations. And I can give you a very good example. It was a transaction where the buyer and seller met during the viewing, and the buyer boasted about all his foreign investments to the seller. And that transaction happened to take, the transfer was scheduled in January, so everything happened in December, and everybody were, trying to rush to go on holiday. I know the buyer had his holiday already planned, and essentially we were waiting for the purchase price to be paid. So my buyer was on holiday. He directed us to his banker. And all that the banker did was tell us the money's coming from overseas, it's on its way, we'll let you know once it's available. And this wasn't sufficient to my seller. My seller immediately remembered the conversation about all the foreign investments and how the buyer played around with the different foreign exchange rates. And he immediately made the conclusion that the buyer was manipulating the transaction because he knew nothing would happen over December, with the deeds office closing, attorneys closing, municipalities being a bit slower. And he automatically assumed that the buyer was wasting time manipulating the transaction, hoping to get some sort of benefit from the exchange rate over the season. So that was his inferences that he drew. But it was a complete misunderstanding based on a conversation they had had. And so it's very important when a client raises something like this that you address it directly and explicitly, that you clarify any confusion. I had another client where the seller said he didn't know that the roof was leaking. He didn't live at the property. The buyer asked the neighbors. The neighbors said, well, he did live at the property. It ended up being a situation of he only lived at the property when his son was in Cape Town, so he wasn't there permanently. So you can see how there could be a bit of confusion, and how the confusion can lead to misunderstanding and escalations. It could lead to clients taking very strong positions, and again, the focus going away from solutions towards fighting and declaring a war. So my tip is always clarify, repeat, ask, paraphrase. So as the agent or conveyancer, I would often repeat to a client what he or she said. I would suggest to them that I just want to make clear what they said. I just want to unpack what they said, or correct me if I'm wrong, but I just want to clarify this point. So that's really important, because sometimes if you repeat something to a client, they start listening to themselves, and they come up with solutions, or they realize that their assumptions aren't necessarily correct, or that they could perhaps have the wrong view of the situation. So yeah, it's really important to just clarify and make sure everybody is on the same page. It's important to listen actively and not just to think about your response. It's also important that when you do deliver a response, to provide your reasons before you provide your answer. If you provide your reasons prior to giving the answer to the situation, you allow the other side to really think what you're saying. They might come up with counter solutions or counter answers. But if you first give them the answer saying, no, we can't do that because this is what the contract says, or you give them a very firm no, or you respond what they perceive as negative, they won't even listen to your reasons. They will just feel misunderstood, that you're not helping them. And so it is a good idea to first provide reasons before giving your opinion in the matter. Do not react to emotional outbursts. Like I mentioned, in valuing your client, acknowledge their emotions and listen to them. It's actually a sign that they trust you. They trust you enough to go to you with their problem and their emotions. So when they have emotional outbursts, don't be party to that, and don't react to that in any emotional way. As the agents and conveyancers, we are the mediators. It's our responsibility to find solutions. And the moment we get involved with emotional outbursts, we lose control of the discussions, and we derail the negotiations that were well on their way towards finding solutions. Another tip for communicating clearly is speaking to be understood. So make sure the client is clear as to what your view or your opinion or what your statement is, and that they don't draw assumptions. Because remember, clients draw assumptions from their own fears, not necessarily from the factual situation. So just keep that in mind, that you really want to consider your words, how you word something, and make sure that the client receives what you're saying in the spirit that you are intending to say it. I think that is so important. To give you an example, let's go back to the complaint about the DB board tripping. You can go back to your seller saying, the buyer is saying you cut corners, you used a cheap electrician, and now there's a problem. Those were his actual words. You can either take that route, or you can tone it down and convey the factual situation. So you can very objectively convey the same message, saying that the buyer has alerted us this morning that there's no power. It seems to be quite strange. Do you know anything about this? Did the electrician mention anything to you? Would you mind if we phone the electrician? So yeah, just think of how you word it, because it could really affect the response that you get. So explicitly acknowledging different views, that's also important. It gives a bit of perspective. So when listening to a client, you could always not counter what they're saying, but you could also add to what they're saying by explaining to them the other party's view. So you can explain to your seller that you need to understand that the buyer is quite devastated. He thought that this would have been resolved as part of the COC. So would you mind if we take this course, or can we find a solution? Would you mind phoning your electrician? So explicitly acknowledging and enlightening one client as to the interests of the other client can really help you to get them on the same page. And then the client should not deduce the other party's perceived intentions from their own fears. So this is typically where your client tells you, I knew he was going to do this. I always expected that he was going to cut corners or not clean the carpets or something like that. Be very careful of that. And when clients make comments like these, it's always best to directly, explicitly address those. Tell your client, wait just a minute. He did get a company to clean the carpets, but they couldn't come because it was raining yesterday. Can they come tomorrow? So there's always a way of addressing a client's fears in a way that they feel that you've heard them and that you are helping them. Be objective and not subjective. So I think this is naturally something that is quite challenging. I think we all tend to go the subjective route, but as the estate agents and conveyancers, it's so important to try and be objective and to always refer to objective standards. Now, the Harvard Negotiation Project came up with a technique called the principled negotiation approach. And what they're saying is that the best solutions that are most efficient and most wise and mutually beneficial are those that are met with objective criteria. Basing your discussions on objective standards really help avoiding decisions that could be deemed to be arbitrary, or it helps us to avoid power struggles. So this is where you simply refer your client to either the sale agreement, market value, legal precedents like court judgments, professional standards or industry standards, or even expert opinions to help assess the fairness. So this would typically be where your buyer, if we go back to our example of the electrical compliance certificate, and your buyer makes a comment saying that he feels that the seller cut corners. That isn't necessarily the case. Being objective involves getting an electrician out. Perhaps the same electrician, perhaps a third party, another electrician. That electrician might tell you, look, the problem with the DB board wasn't this or that. There was a big storm and it ripped out a cable or something like that. But trying to be objective or referring your client to a legal position, like possession only passes on transfer, or the sale agreement is quite clear on this point regarding the creepy crawly. It has to stay, Mr. Seller, you can't take it out. Once you refer your client back to the objective standard, they won't see it as you asking them to conceive that they were wrong in doing something. It will appeal to them and they will identify with the objective standard. Let's take the creepy crawly example. If the sale agreement reads that all pool equipment are part of the sale and the seller takes it out, going to your seller saying, Mr. Seller, you were wrong, you were not allowed to do this, won't be the way to go about it. A good idea is to rather refer your client to the contract saying, I just want to, maybe you can correct me if I'm wrong, but I just want to check in with you. It seems like the creepy crawly is missing. Do you know anything about it? Your seller will respond saying, yes, of course, I took it because the one at my new house is broken. You can always refer your client to the sale agreement, which is the objective standard, and say, I understand that, and I'm sorry the one where you're buying is broken, but I don't know if you saw, but in the contract, this is what it states. So just directing your client to the contract could resolve the issue. We don't ever want the client to feel that they are losing face or they're looking bad or that some perception of them might be tainted by what they did. It could clearly be a case of a misunderstanding. We rather want to help our client to find a solution and to agree with the objective standard. So clients cannot haggle about the law. They cannot haggle about the contract if it's clear. So another tip there is to make sure your contract is clear. Make sure when you sit with your client and you're discussing the contract and you see they might not be sure or they might not understand a provision of the contract, to clarify it and just make sure everybody is on the same page. Frame each issue as a joint search for an objective. So what you would simply do is you would state the dispute or the problem in objective factual terms. and you will deem the parties to be partners in finding a solution. So you would typically approach both parties to say, look, fact of the matter is there's a problem with electricity. How can we resolve it? So that will get them on the same page, and that will ensure that both clients focus on finding solutions instead of attacking each other. Avoiding reactive devaluation. So this really just adds on to what we've been saying. Clients could view the other client as the adversary. Clients tend to assume that they are involved in a win-lose situation. It's a war situation, and they automatically assume the worst. And I think it's our responsibility to try and take that out of the equation. They shouldn't be seeing each other as adversaries. If the substantive dispute is declared as something which is factual, and we steer the clients towards focusing on finding solution, it would really help us find solutions that could work for both. We want to avoid undervaluing proposals from the other party. I gave you the example of the client that was going through a divorce and the suggestion to make the garage available for his furniture to be moved across. So that is really such a great suggestion from the seller side to help the buyer. And if the buyer responds negatively to that or doesn't really value that proposal or concession made by the seller, it won't help us find a solution. Your buyer could easily respond to say, I don't want that. I want to move in. I don't want to get another team to move my furniture from the garage to the house. Why can't I move in? Your response would simply be to refer them back to the objective criteria to say, Mr. Buyer, the sale agreement says you can take occupation on registration. We haven't registered yet. We're waiting for the deeds offers. And this offer by the seller is actually a very nice offer. You should consider accepting it. The alternative is getting storage, which will be expensive, not only the storage fee, but also for you to get movers. So it's really important to stress the value of a proposal when it comes to negotiation. Evaluate each proposal based on merits, not on source. So it's good to unpack proposals and to just clear out any assumptions and to clarify why you think it's a good or bad proposal. Addressing assumptions, like I mentioned, is really important. We don't want anybody to sit with any feelings that are unaddressed, and we don't want anything to simmer and escalate into a negative situation. Then the blame game. So we've all been involved with transaction where parties start blaming each other. We were recently involved with a transaction where the buyer and seller they just had a lot to say about each other. It is so negative. It really just leaves the whole situation quite negative on both ends. It's supposed to be a very exciting time for a buyer to move into a new house. The same with the seller that is moving, starting with a new chapter. So we really want them to be positive. We want them to be happy and look back at the transaction with positive memories. We don't want them to be stuck with tainted experiences or circumstances. So try and stay away from the blame game. If your client is tending to engage in the blame game, I would steer them towards the future, steer them towards a solution. I would acknowledge the client's feelings, saying, I know you are disappointed. I know this is your new home. You guys just got married. You're so excited starting out in this new house. I realize that what happened is not in line with the sale agreement, but let's work to finding a solution. I'm here to help you. What can I do to make this better? So I think it just re-emphasize that you are the client's partner and that you are not just taking your fees and making a run for it, but that you are working on the relationship with the client. Okay, then something which I think is so important is being creative. So finding creative solutions is really part of what we do to make sure that our transactions are run smooth and quickly. So clients often see negotiations as win-lose, about winning or gaining territory, and that should really not be the case. There are many ways to skin a cat. There are many solutions, and if one really thinks about it, you can address clients' respective interests or concerns in such creative manners that their positions won't necessarily lead to further conflict. So, what's really important is planning before you chat to your seller or your buyer about solutions. Do a bit of planning and think of alternatives, how you can meet their needs, whether it's storage, whether it's access, or changing dates or accommodating each other in a different way. Before you go into a meeting, which could be quite stressful, it would be good to do a bit of planning in advance. Look at the client's interests, something that I mentioned before. Look at the interests and see where they overlap. When you've reached a deadlock, it's often a situation where your clients would say, look, I'm going to walk away. I just recently had a client where it was a seller, and he was taken aback by the huge repair bill that he got from the gas guy. And he instructed me to tell the buyer, if the buyer does not pay for the gas repairs, that he is going to cancel the transaction. So he very boldly took in a position. And I had to chat to him. I had to tell him, look, we have to look at what the law says. We need a gas certificate prior to registration. We need to look at what the contract says, that you are responsible for the gas certificate. Let's start with getting different quotes. Let's try and find some solutions. But unfortunately, objectively speaking, this is the legal position. And it's in your interest to make sure you get a good gas guy out. Because the last thing you want is to move. That client was leaving the country, was going to New Zealand. The last thing we wanted is for him to sit in New Zealand dealing with complaints about gas issues. So yes, we had to have that discussion, look at their interests, and on the buyer side, obviously getting a good and proper gas certificate was in his interest. So just looking at the interests could lead you to some creative solutions. Insist that the solution meets an objective or a standard. So we can be we can be quite stern on insisting that the solution has to be fair and reasonable and in line with a legal position. And that's simply because the client needs to realize if the shoe was on the other foot, they would want a solution that is fair and reasonable. And those standards really appeal to everyone. So it's something that your client will identify with without feeling that they have given up territory or they've made concessions. A few techniques that I would like to point out is avoiding judgment. If you are the agent or the conveyancer on the file, try and avoid judgment. We are not judges, we are conveyancers and estate agents, and finding solutions is far more important than being the judges in the situation. By making a judgment would tell one of the parties that you're actually not interested in their circumstances or the challenge that they are facing. And so it's altogether something that also limits creativity to find solutions. So try and avoid being the judge. Look into the cause of the problem and see if you can find any answers. We had a situation of a leaking roof, and it ended up being a very quick fix. There was a storm, and the satellite dish was something affected the position of the satellite dish, and water came in through the little holes in the wall. So it was a very quick fix. By just fastening the satellite dish, the problem was solved. So involve third parties like experts, like plumbers, electricians, attorneys, advocates, get opinions in, because there are many ways to find solutions. Putting forward various solutions can also help your client make a decision. Sometimes putting forward alternatives will help your client realize that the first solution that was suggested by the other party could perhaps be the best solution of all of them. Going back to our gas situation, I could simply tell the client, look, without a gas certificate, I can't register. His response was, well, then I'm going to cancel this transaction. And my response was, the problem that I have, and I'm just thinking as the attorney independently, is that if you cancel the transaction, unfortunately, you will be in breach and you will have to pay the estate agent's commission and any damages that the buyer suffers. So giving the client the layout of the process and various suggestions helps them realize that the other solution that was proposed by the other party, it's not such a difficult or problematic solution, and it's worth considering. Rephrasing or qualifying a proposal, that could also be helpful. So that is where you ask your client to be clear about what their expectations are or what they are suggesting, or maybe take their suggestion and just qualify it a bit. That could also help them. Okay, temporary solutions. We don't always have to find the final solution. Sometimes a temporary solution could also work. So again, it comes down to being creative, thinking about stuff like storage or alternative accommodation or something like that. And then making the decision easy or attractive. Sometimes you can say the same thing or make the same proposal, but in different terms that could appeal to the client. So you could tell your client, look, I do realize that it will be uncomfortable to have the buyer's furniture in your garage, but we need to remember they are moving from Port Elizabeth. It will be so expensive if they have to go to a storage company or Airbnb. Can we make a plan? Are you able to move out a day earlier? So yeah, just try and explain to your client that if we can't do this, it will be so negative. The reason why the transaction is late is because you didn't pay rates figures. So I'm concerned that if the client has to use storage, he might come after you to cover those fees. And then your client will realize, wait a minute, making my garage available for his furniture, it really isn't such a bad suggestion. Yeah. So there, like I said, there are many ways to find solutions. Having your fallback plan ready, that's also comes in with planning. So often when we approach clients, we've got suggestions how to solve the problem, but we always need to think of what if they don't agree? What are their concerns? What are their interests? And what if my solution does not appeal to them? So that would typically be, like I suggested, if the parties can't agree, we can't register, the transaction will have to come out of the deeds office. Having your fallback position clarified really helps you to know how to manage this process. And sometimes it could really help to disclose that to the client, to say, look, if we can't find a solution and the buyer stops the transfer, we have a big problem because then you can't move in where you are buying. So maybe just clarifying and explaining to the client what the alternative is could really help us. And sometimes it actually also helps to just walk away from the conversation. This is after hearing the client out, putting in a good effort to find creative solutions that are objectively fair towards both parties. It could help to tell your client, look, this is the solution. I think it's fair, but if we can't come to a solution, we're going to have to walk away from the discussions, and I'm not sure what will happen to the transfer. It will likely not go ahead. So being prepared to walk away, if really necessary, could also help the clients realize how serious this is and that a solution is necessary. Okay, so guys, those are the techniques that I would like to suggest. I want to really just confirm two things. And first of all is when there's a dispute on your transaction, don't just leave it. It won't just go away. It might go away, the transaction might register, but your relationship with the client will be compromised. So my advice is tackle the dispute hands-on. Don't just leave it, because it is an opportunity for you to convert the situation into a strong relationship of trust and potentially some future business coming from the same client. Then our solutions, and the best solutions, are always solutions that address both parties' interests and that are based on what is objectively fair, as well as what the law or the sale agreement or the objective standard could be. So it's about mutual interest and objective standards. I do have a few for you that I would like to highlight. And number one is think of the way you talk about the dispute. It's not necessary to include any blame or to say who's responsible for what. It's sometimes sufficient to just objectively state what the problem is. Mr. Seller, it's the day of transfer and the roof is leaking. And then you could perhaps pause and see how he responds. He might respond saying, "Oh, is it in the garage? That is an old leak." Or he might say, "No, there hasn't been any leaks ever. I lived in the house for 20 years. I'm not aware of anything." But just think of the way you talk about the problem and try and frame it within an objective, factual way to ensure that there are no emotions being escalated by the mere fact that you're raising a dispute. Clarify remarks and misconceptions and address them directly and explicitly. It's not wrong to correct your clients. So you could easily correct your client if they're saying something which is inaccurate. To say, I gave you the example of the client who didn't permanently reside at the house. I told the buyer, "I'm sorry, I don't know who told you that the seller lived at the property. I know for a fact the seller comes from Mossel Bay and they only used this property when their son was visiting from the UK." So you could correct your client if necessary. Don't dismiss comments. I had a client where he mentioned to me that they were going to a wedding in December and they would like to move before the wedding because the entire family is coming to their house. And so this is something which is irrelevant to the transfer, but it was so important. And the fact that I worked with that and I reminded him that I knew about the wedding and I was working very hard to get the transfer through before this wedding, which is completely irrelevant to my transaction and doesn't affect my seller, really meant a lot to him. He felt value, he really appreciated it, and they were very excited. They moved in a week before the wedding and everybody came and saw their beautiful new home. So it all worked out well. Don't choose sides. I know we tend to choose sides. We tend to make our own assumptions and we tend to be judges, but don't choose sides because it won't really be conducive. And the client will very quickly pick up that you are not on his side. So rather steer the conversation again towards objective standards and make sure your client feels valued, or that your client is valued and heard, and that we are able to help them in a way which is fair. And then put yourself in your client's shoes and show a bit of empathy. Like I mentioned, clients don't always deal with with the sale of houses, and their houses are their biggest assets or likely to be their biggest assets. So let's empathize with that and let's see what we can do to make life a bit easier and to help stop the negativity. So guys, that's all from me. This is the first of 2 sessions. We are going to do another session later this year, which is going to deal with situations where you really struggle to get the clients on the same page and where it's a bit more difficult and challenging to find solutions. So I hope you enjoyed the training. I have shared my email address. You're welcome to reach out to me if you have any questions. Thank you for your time and have an amazing day.